video tutorial provides a brief overview of the United States court system. There is more than one court system in the United States. The federal government has a court system, and each state has their own. These different systems have the same basic hierarchy, which are trial courts and appellate courts. There is a lot of really good information regarding federal and local courts that are posted on these websites. Law schools and other official sites also contain good information. What we will discuss today and more can be found on the sites listed here. I encourage you to look at these sources to learn more. These videos will cover a lot of legal terminology. Remember, there are many legal terms and definitions. These videos will provide just a small sample. Please consult a legal dictionary or legal encyclopedia for more examples of terms and definitions. Trial courts can have either limited jurisdiction or general jurisdiction. Limited jurisdiction means a court is limited to hear a certain type of case, for example, traffic court or small claims. General jurisdiction means courts can hear a wide range of cases, from divorce to fraud to homicide. We will talk a little more about jurisdiction in our next video. Appellate courts are provided if lower court rulings qualify for a second look. Some appellate courts are required to take a case. This is known as an appeal of right. Not all cases qualify for an appeal. Discretion can belong to the court on what cases they choose to hear. Trial de novo is a circumstance where a new trial is performed at the appellate level. It is conducted as if there never was a trial before the appeal. Appeal de novo is where the appellate court uses a trial court's record but reviews the evidence and law without deference to the trial court's ruling. The federal court system is divided into district courts, circuit courts, and the United States Supreme Court. The federal courts have limited jurisdiction and can hear cases that cover the United States Constitution or federal statutes. Congress did create 3 Article I or legislative courts that do not have full judicial power. These are subject-specific courts. They are the U.S. Court of Appeals for Veteran Claims, U.S. Court of Appeals for Armed Forces, and U.S. Tax Court. Bankruptcy court is another subject-specific court with its own rules and procedures. District courts are trial courts. There are 94 district courts throughout the United States. Hillsborough County is part of the Middle District of Florida. Each district has a United States District Judge that is appointed by the President and confirmed by the United States Senate. It is a life term. These courts handle both civil and criminal trials if they qualify as having issues pertaining to the U.S. Constitution and federal statutes. For circuit court, or the first level appeals court, there are 13 circuit courts in the United States. Once a federal district court has decided a case, it can then be appealed to the United States Court of Appeal. We are in the 11th Circuit, which includes Alabama, Florida, and Georgia. Cases from the district court are appealed to the 11th Circuit Court. The main court is headquartered in Atlanta, Georgia, with satellite offices in Miami and Jacksonville. Circuit court judges are appointed for life by the President and confirmed by the United States Senate. Any case may be appealed to the Circuit Court of Appeal once the district court has finalized a decision. Appeals to circuit courts are first heard by a panel of 3 judges. Each party files a brief that argues why a decision should be affirmed or reversed. The court schedules oral arguments where attorneys come before the court to make their argument and answer questions from the judges. There is only one Supreme Court of the United States. It is in Washington, D.C. and has a panel of 9 justices. They are appointed by the President and confirmed by the United States Senate. They are lifetime appointments. After a circuit or state Supreme Court has ruled on a case, either party may appeal to the Supreme Court. This court is not required to hear all appeals. Parties ask the court to hear a case by filing a writ of certiorari. If the writ is granted, the Supreme Court will accept briefs and conduct an oral argument. If the Supreme Court does not grant the writ, the lower court's decision stands. Less than 1% of appeals to the Supreme Court are heard. Like the federal court system, the Florida court system is divided into several levels: county courts, judicial circuits, district court of appeal, and the Florida Supreme Court. County courts are trial courts. There are 67 county courts in Florida. The state constitution established one county court for each county. Most of these courts deal with civil disputes such as traffic offenses, misdemeanors, and small claims. The main Hillsborough County Court is in Tampa. Plant City also has a courthouse. The judicial district contains both trial and appellate courts. Florida has 20 judicial circuits. These courts have general trial jurisdiction over matters not assigned by statute to the county courts. They can also hear appeals from county court cases. Hillsborough is in the 13th Circuit. The District Court of Appeal is an appellate court. Florida has 6 district courts of appeal. Hillsborough is in the 2nd District. This court is currently located in Stetson's Tampa Law Center. A new building is being built in St. Petersburg and will open in the future. Decisions from this court tend to represent the final appellate review of litigated cases. The Florida Supreme Court is the highest court in Florida. The court is composed of 7 justices, and at least 5 must participate in every case. At least 4 must agree to reach a decision. The Florida Supreme Court must review final orders imposing death sentences, district court decisions declaring a state statute or provision of the state constitution invalid, bond validations, and certain orders of the Public Service Commission on utility rates and services. The court, at its discretion, may review a decision of a district court of appeal that deals with Florida statutes, Florida constitutional or U.S. constitutional issues. It can hear an argument on a district court decision that conflicts with another district court decision or a previous state Supreme Court decision. The Supreme Court also renders advisory opinions to the governor upon request relating to the governor's constitutional duties and powers. In the next video, we will get into a little more detail regarding jurisdiction.